they gave us no choice. I said, all right.
Our main theme was really connecting the dots.
Welcome, friends. My name is Chad Sands, and I am the VP of Marketing at Cloudlex and editor of the Trial Lawyers Journal. And today we are going behind the verdict. In 2017, a 24-year-old man fell from a crumbling New York City subway platform and was hit by a train. He lost 5 toes and nearly his life. The defense? The MTA claimed he jumped, that he was trying to commit suicide, and they had a teenage witness to back that theory up. Nick Liakas is a New York City trial lawyer and senior partner at Liakas Law. He's made a name for himself taking on complex, high-stake cases against powerful institutions. Jessica Brylo is a nationally known litigation consultant and the founder of Trial Dynamics. She helps trial teams shape stories, select juries, and frame winning cases. So to get to the stories and behind the verdict, I asked Nick, how did this case come to your office?
We got a call from a new client. It was actually his family member. His name was Maroof Hussain, and that was the name of the plaintiff in this case. And at the time, he was 24 years old. He was working in a catering delivery business. He would basically drop off food and set it up. He came from Bangladesh. I think it was in 2012 when he came to this country. His uncle had gotten him a legal status in the United States. So he came over for work, started in construction. You know, he did a lot of heavy labor type of work. And then he found himself a job in catering, which was actually right by my office. And I really think that's how he found us. I don't know if he's ever delivered to our office. He didn't necessarily recall. I don't recall. But his catering company, like their headquarters, essentially, it was around the corner from my first office. So this case we took in 2017. Our office was maybe 2 years old, and I had just become an admitted attorney.
And so it was just like a phone call in, but you kind of think he recognized your name and knew of the firm?
That's my thought, but it was a direct case to us. We got a call, and as soon as we got it, I went to the hospital to meet with him.
You did?
Yeah. I went to the hospital to meet with him and his family. And he couldn't obviously bring us to the train station where this happened. It wasn't too far from where he was. He was in a level 1 trauma, Jacoby Hospital.
And so did you guys, like, in terms of Liakas Law and did you guys go to the platform and start taking photos immediately? What was like the next steps of after you kind of first met with the client?
Well, first we meet with him. We get what he can recall, what he remembers. Obviously he had been through a major trauma, so things can, be a little difficult to recall. And sometimes you don't want to recall certain things, but, he was able to tell us very clearly. And his story, one thing about him, his story never changed. That's why I was so confident in him, even in the face of this defense, which kind of shocked us. Speaking with him, I never had any concern that he had any mental breakdown or he was any, EDP, emotionally disturbed person, as it's usually referenced. But he seemed like a really nice, hardworking, genuine guy, young kid, 24. So we took the case, we went to the platform, and he said, I stepped on the platform and my foot, the way he described it was my foot just kept going down. So I didn't really know what he was talking about. Does that mean you missed the platform and you just stepped off and stepped into the track portion, and that's what you mean by just kept going down?
Yeah.
So I didn't know. So we went to the station and we got an engineer down there, and the engineer started taking measurements and photos and testing, and you could actually see the edge of the platform. It's called the rub rail. The rub rail was all chewed up. It was rotten. It was wood. They used to use wood. Now they changed it, the Transit Authority, to something else. And interestingly enough, this morning I was doing an inspection on a similar case. A 24-year-old girl lost both of her legs, unfortunately, last week. I was doing an inspection of a station, and you could tell that they changed all of these rub rails from wood to this composite material, which is not much better, by the way. The exact area where he, quote unquote, tried to commit suicide had massive defects right on the same section that are clearly a tripping hazard.
So you mentioned that the accident happened in 2017, and then it didn't. The trial didn't happen until 2025, just a month or so ago, right? What was kind of like the first reaction with the MTA? When you guys did file, what was the response and kind of going? When you guys started to move forward?
We don't get a response from the MTA. You don't get a response from the Transit Authority. I most of my practice is New York and New Jersey. I don't know what in other areas of the country if how diligent these municipal defendants are in terms of their litigation strategy and their reaction to things. In my experience, they don't even look at the case until it's the day before the deposition, and then they try to get things together, and then again a month or two before trial when they try to put their theory together. So we didn't get a reaction from the city. We don't expect a reaction from the city, no matter what you put on that notice of claim. I've put $1 billion, $500 million. I did one yesterday for $150 million. They just like water off their back. They don't react.
Okay, so at what point, Jessica, were you brought in?
We have worked previously on other cases, but I was brought in, I don't know, we maybe 6 months ago, something like that. We initially just started talking about how to frame the case and jury selection and things that he might need on my end. And so that's when we started looking more into the facts of the case and meeting up. And I flew out once for jury selection. We didn't get a jury, so we used it as a work day and started talking through issues in the case, and then flew back. And then we kept talking about the issues back and forth, multiple texts. I mean, at 10 o'clock at night, we'd sometimes be talking about the case and trying to figure out what to do with the facts that we had.
I saw on LinkedIn you had mentioned that you guys had spent over 20 hours kind of framing the case. Can you talk a little bit about what that means and what your guys' approach was when you first started kind of brainstorming and working together?
Yeah, it varies for every case, but to me, case framing is all about how you want to present the story. So there are always facts in a case that you can't change, but there's a story that you can make up with those facts, and the stories can differ drastically. And so it has to do with order of proof, and it has to do with who you want to be the villain and how you're going to accept some of the problems in your case and in which ways we do that. So those are some things that we talk through every time I'm doing case framing, but certainly in this case as well. And things evolved in this case over time. So the framing shifted as we would go through and figure out what we needed to do, because there was a point in this case when, when we first brought it to me, and I won't go into all the facts because, I'll let Nick give you all the facts, but I said we need to settle this case. And then as that didn't happen, we looked further into the facts and had some things to work with. And so we picked up on those and tried to run with them to the degree that we were able.
The stories are so interesting. It does literally sound like a John Grisham novel in terms of some of these twists and turns and the deceit with the witnesses. I mean, I guess initially, Nick, were there any major hurdles to the litigation, before you guys kind of got into discovery and started like uncovering the truth, for lack of a better term?
I mean, discovery was relatively uneventful, honestly. I mean, I wish I had a better story to tell about the discovery, but whenever you're dealing with the MTA or the Transit Authority in New York, it's going to take more time. You're going to have to make motions. They're not going to give you full responses. They're going to fight you for their internal documents, their records. So we had those fights, but that's par for the course.
Right.
The real shocker didn't come until it was, I would say, 4 or 5 months before trial. This is after we contacted Jessica, and we were coming up with the framing of the case, which I will say is invaluable. I remember, when I spoke to Jessica first, she said, "What kind of case is this?" I said, "It's a trip and fall." She's like, "No, it's not. It's a defective platform." Like the little thing. So, but that in my opening, I never said this is true. I said it's a defective platform case. That was the first line in my opening statement.
Right.
Little things like that, which are just invaluable. But
and then I guess, Jessica, real quick, because you guys did frame it around the kind of the bully. The MTA is the bully, right? And did you guys initially come up with that, or did you come up with that after you kind of started uncovering what was being hidden?
Yeah. It was a process, and I wouldn't even say we framed them as the bully because we didn't have enough to go there. we really had to make this we hinted at it, we insinuated some of that, but we didn't have, despite multiple attempts at background checks and trying to do investigators, we could not find the links that we needed to prove what they were actually doing behind the scenes. So we had to go gently, because you never want to be ahead of the jurors. If you're more angry or you're further down the pipeline than they are, then you're in trouble. So we didn't want to be in that position, but we also felt like they probably could catch on. But if they didn't, didn't want that to be the hill we died on. So it was a really, really fine line that we had to walk. So our main theme was really connecting the dots, that their story didn't connect, and everything else in his story and his background. And, there was no history of suicidality. There was no doctor's appointments for it. Now they would say, well, that's because of his background and his religion, it was taboo to commit suicide. So you wouldn't see any of that. But where he fell and where they said he fell, and putting all this together, our story was much more coherent. So we started with a connecting the dots theme, really. And as we got further into it, we tried to show with timelines as to what the MTA did at what times, and taking apart this witness that I'm sure we'll get into, that there was something fishy going on behind the scenes. But we really had to let the jurors get there before we could go there.
You guys didn't kind of plant that seed in the opening yet?
No, we didn't have it. We really didn't have it. And Jessica is spot on. We had our suspicions. We had multiple investigators trying to do background searches on this witness and trying to figure out through Facebook and all kinds of stuff what the connection, why is this witness, who was 15 years old at the time and not on any of the statements, on their witness statements, it wasn't listed on anything, all of a sudden shows up 2 years later, and they do a witness statement. And they say, well, she's referenced on the reports, but it's not her name. It's her mother's name, who didn't witness anything. But because she was 15, they didn't list her. And it was all convoluted, which, again, maybe that's the case. I don't know. But we couldn't really put it out there. We could insinuate, like Jessica said. We could, kind of drop a little bit of what we felt. But I couldn't open the case and say, they made this witness up. They made up these statements, and because we didn't have it. It wasn't until about halfway into the trial where, I spoke to Jessica. And I was like, I think we have it. We got it. Their operator seemed to be totally lying. Their station cleaner seemed incredible. Their experts got destroyed, and I don't say that to pound my chest, or I didn't do anything. In my mind, I didn't do anything special. They just fell apart. Now, on some basic questions, they fell apart because their narrative didn't make sense.
I guess before the trial, Jessica, I've seen, again, on your LinkedIn, you're kind of mock trial, den that has all 13 it looks like a cyber hacker or something. You got Bubba Fett in the back. Did you guys do a mock trial or a mock jury for this?
I'm going to let Nick answer that question.
So Jessica has been trying to get me to do big data for
and focus groups. Yeah, all of it.
For a year or two now. To be fair to Jessica, she's probably right. I think the result in this case worked out, but it would have made things, I think, a lot clearer in terms of how people felt about certain aspects of the case, what to ask for in closing and everything. We didn't have that. I will take her up on it, and I will do the big data study. I don't know if you guys are familiar with any of that stuff. But.
Well, Jessica, tell us about the big data study that you kind of maybe pitched Nick, but he passed this time. But next time, he's all in on it.
Let me be clear here. We both have to take, I think, some reality on this one. I didn't do the big data. Jessica and I were about to settle this case beforehand. Once we got this witness testimony, we were like, all right, what are they offering? This is a problem. She's standing 5 feet away, and she says that he jumped in front of the train as it's pulling in, with no time to spare. It was horrible. We were ready to go, and then we end up doing a non-party deposition a few months before trial for the teenage girl. No, she had never been deposed.
So it sounds like on the report, her mom was listed, and the MTA was maybe saying, "Oh, well, the girl wasn't listed because she was a minor, but the mom was there, and that's how she's connected. Obviously, she was with her mom, and look at you, she came out of nowhere, and now."
And I will say, when he sent me the video of this girl, he did a deposition of her quickly after. I watched it. I was like, Nikki, this is bad, because she seems extremely credible. She testifies well. She seems authentic. She's a 15-year-old lifeguard who's probably, good at looking for things and supposedly disinterested. I said, I can maybe get over the MTA people saying he jumped, right? They're connected to the MTA. I don't know what to do with this witness. This is a big problem.
Yeah. Like a nice 15-year-old lifeguard girl. Like, why is she going to just make something up about this?
Yeah. That combined with some other issues. I mean, the defect is on a yellow strip next to where the train comes, and you're not supposed to step on the yellow, So in any sort of trip and fall case, I will never say it's a trip and fall case, but in a trip and fall case, that's a big problem, that he's walking where he's not supposed to walk. Now, where we started with this is the platform was extremely narrow. It was not built well. I don't remember how many inches, Nick. I know it was really narrow.
The actual concrete walking surface was only 13 inches. And then you have the tactile strip, which is about 24 inches, if I remember. And then the rub rail, which is the last portion of the platform where that's the actual edge, is about 4 inches. So I think it was about 41 inches, or just about around 40 inches for the entire section of the platform.
Yeah. So if you're passing people and there's people there, I said, did you sue based on a defect of how this was constructed? And he hadn't. And I said, I think that's a major part of it, because the only reason you step where you're not supposed to step is because you're pushed into it. So that's where we sort of started with everything, was even just figuring out, did he trip where he said he did, because they had him falling somewhere else? How are we getting around the fact that he's walking where he's not supposed to walk? And then on top of it, they're saying that he committed suicide. So with all of those facts, I said, this is a bad case. We've got to settle this. Now, where we get back to focus groups and mock trials is and big data. If you do a focus group or a mock trial, which is what most people know of, just you talking to people, you get 2 to 4 groups in a room and present the case, let them deliberate, ask some questions. As we went through this and we started figuring out issues with the witness, during trial, he would ask things like, do we put in her statement? And there were really good things for us in the statement, that it did not sound like a 15-year-old wrote it. And there were bad things in the fact that if people are reading in black and white, he jumped, I saw him jump, does that make it more real? So when he's asking these questions, I would laugh and I'd say, well, I don't know, because we didn't run it by people, right? So I don't know which side wins out. So if you test the case ahead of time, and we have all these people that think this statement is for sure not written by this girl, and somebody tampered with her and wrote the statement for her, then I know for sure we need to put the statement in, which is where I was leaning, but I understood his position on it. Yeah. So, testing the case helps in that way. If you move it then to a big data study, big data studies are online studies. You don't get to see the people. You don't interact with them. They're not as good for case framing. They have some case framing abilities, but it's not the same as listening to people for hours talk. What they are very, very good at is predicting the win rate and telling you what number to ask for. And then they'll also give you a juror profile, among other. I mean, it's a 60-page report. There's a lot in there. I work directly with the Campbells, so that's who I run them through. And so what we wanted out of that, if we were to have time to run it and had done it, then we would know, when he says, well, how much do I ask for? I would have known the answer to that, because what you ask for changes not only what you get, which makes sense, but it also changes your win rate. So by asking for the wrong number, you may entirely lose the case, and nothing else has changed other than the number you ask for. So it's a really big deal to know what number to ask for. So, I sort of had a gut feeling about the case, but if we had tested it, then I would know exactly what to ask.
Did you ask for something, Nick, in the opening?
No, not in the opening. I just said, and during selection, we were letting the jurors know already, how do you feel about me standing here at the end of this trial asking for many millions of dollars? I wanted to find out what were people's, feelings about that. And, we talk on both sides too, what about zero? What about, but obviously, focusing in on, don't be surprised when I'm standing here at the end of this case asking for many millions of dollars, kind of leaving that open. And in closing, I did ask for a number. They didn't give it to me, but What are you going to do?
Next time. Like, speaking of jury selection, how did that go? I mean, Jessica, you mentioned you flew out there. You guys couldn't do it. You turned it into a long working session. Then you had to come back out. How did the jury selection go?
I don't know where your listeners are from, but New York jury selection is an interesting creature. There's no judge in the room, which is not like most other states in the country. And
there's no judge in the room for jury selection in New York.
Correct.
No.
And
at least not where we are. Yeah.
And I've heard, like, in Arizona, I think the judge does the jury selection in Arizona.
Which I think is worse, probably. I'm located in Colorado. Where I'm at, you get 20 minutes. So we're done by lunch. But, it takes a while to pick a jury there. Some of the issues that we got into with the jury selection part is once we knew who the jurors were, I'll let Nick tell the story of sort of negotiating with the opposing counsel as to how we were going to do the jury selection. Maybe I'll let you do that first, and then I can chime in on selection itself.
What was the opposing counsel saying, Nick?
I mean, for me, it was a pretty standard jury selection. I mean, I know Jessica is not used to the New York model where it's more of a free-for-all. But I mean, we teach this here in our office. Jury selection, to me, is, I don't want to say the most important part of trial, but one of the most important parts of trial. I think more trials are won in selection than by a closing statement or something like that, because you really have to try to weed out people that are not going to give you a fair shake. I mean, and that's really what and it sounds kind of cliche because we want fair jurors. Everybody wants a juror that's going to be good for their case. Like, what do we, let's be honest. Right. If the other side doesn't oppose of a juror that is going to be tremendous for you, I'm taking the juror. Like, that's not on me. That's their responsibility. So in New York, it's a little bit different. We've picked juries in federal court, obviously. Then that's a whole different ball of wax. You have no control. You're basically sitting there. In New York, it's a lot different, and it's extremely important because the issues, the defense will know their issues. They'll do the same thing. Everybody has equal opportunity to address the jurors. But if you really frame out your case the right way and you know how you're going to close before you even pick your jury, you can really start to subtly press your theme, even in jury selection. And you could find out who is kind of into this theme, and that's who we want. We want to go there. But there was a little bit of gamesmanship in jury selection, that I think that's what Jessica's alluding to. But that's par for the course. Really, it's normal. We try to.
What was it? What was the game? What was the gamesmanship?
He wanted to put only 6 up there and then refill after you use strikes on those 6. And I would prefer to have more like 12 to 18 because as you use strikes, you have no idea who's coming. So you don't know whether you want to use a strike on the person or not. And so we ended up compromising at 9, I think, in the box.
We sat 9. And it just goes to show you it's more of a negotiation even in selection, right? There's no black and white. There are some formats that, are standard. Usually you'll have a conversation with opposing counsel. Which method are we using? How do you want to do it? Everybody's got the ground rules.
So, I mean, Jessica, like, are you like at a table, like running public records reports, like trying to get like information on the jurors, like all in real time? Is that what's going on?
It depends. I don't think we ran it in this case. Some cases we do. I have a team that will be in the background and sending me that information because I need to be there listening to the jurors. So I can't be running the reports while I'm there, but they're running it and sending me the information if we're doing that. In this case, I'm sitting there just listening and taking notes. And it's really, half the battle is figuring out who the bad jurors are for you. And the other half is figuring out how to use your strikes, because it's not just about this is a bad juror, strike them. You have to be thinking ahead. If for example, I think there was a point during jury selection that I did not like 3/4 of his whole front row that we were going to get to. And so if you pass on strikes and you retain those strikes, I'm thinking ahead, if I can get to juror number 20 and 21 and have them be alternates, those are the ones that I want to be there. So how do I get there? If I strike these, he's going to strike, then we strike, then he strikes, and then I pass. It's a game of chess to figure out how to get there. Now, at every move, you're taking a risk. So sometimes I will accept a juror that I think is a C because I'm okay with some C's on the panel if I can keep some of my A's. So if you say, well, what if he accepts the panel? Even if you have a D on there, that's a follower. Well, if he accepts the panel and we still have 2 or 3 A's versus having all C's, that's still a better jury to me than having everybody who you've got nobody on your side. You go through all these strikes, you often end up with all C's who are just completely neutral. And if you can get a couple of really strong jurors on there at the expense of having an iffy juror or two, that's still a better panel. So you really have to think through who's coming, how do I use the strike, not just who's bad for me.
Okay, so you guys got the jury selected. And at this point, all the cards were kind of on the table, right? There was the 15-year-old witness who said he jumped, and there was the
conductor who said he jumped, the station cleaner who said he jumped.
Just our guy who says he doesn't.
Right, there's the guy who fell and lost his toes says he didn't jump.
I think one of our better pieces of evidence that we could use is if we disprove that he tried to commit suicide, then what's the alternative? He fell, right? They're going heavy on the suicide thing. So what we did was we retained an emergency medicine expert who went through all of his records and, found that there was a psych evaluation done a few days after this happened. They took a full history. He never had any suicidal ideations. He never had any issues with mental breakdowns or depression or anxiety or no psychological history whatsoever. So to me, that's a great fact. He hadn't, since he had an amputation and all these injuries, he never had any suicidal attempts or nothing. That's another really good fact. So we retained this expert who came in and gave a whole rundown of his psychiatric history. And he found in the thousands of pages of records, he found a 3-page psychiatric exam that was conducted. And it was like pure gold for us. It was like, this guy didn't try to commit suicide. He had everything going for him. He was getting married the next year. Which he didn't end up getting married. He was making $1,000 a week. He's got a stable house. He's got family around him. He's got, no issues. He's denied it. And he was able to come in and say, listen, if someone's going to commit suicide, it's usually a call for help. And this guy's immediately saying, I didn't do that. Now, the defendants took that and they tried to make that their positive and say, well, because he's Muslim, because he's from Bangladesh, those are all taboo and he'll be shunned from his community now that he survived. And, they went there with it. And I was happy they did because it just made them look ridiculous. Yeah,
maybe the jurors didn't really buy that.
Well, the jurors, when he started with that, with our emergency room expert, he started asking him, isn't it true he's a Muslim and it's, against his religion to commit suicide? And the jurors were started to scrunch their face like, well, what?
Where are you going with this?
And then they brought up his sexual history. He wasn't sexually active. Maybe that's a reason.
So he must want to commit suicide.
I closed on that. My closing was maybe they don't think his life is worth living, but to him, his life is everything. It's beautiful, and I think that resonated with the jurors.
And then what about the 15-year-old witness? How did you navigate that? In terms of, are you just going to go full attack dog mode on this 15-year-old girl?
We gamed that out also. We watched this video. I probably watched the video 10 times. I know Jessica did. I know Jessica's husband watched it. My wife watched it. We had like a whole panel here because we couldn't figure out what is this person's incentive? Why? Right. She's not an employee. I highly doubt, that they were doing something, egregious, like, promising her things or giving her, I really, that to me was like, why? Like, what is her incentive to come and say this? Which is why we couldn't commit to the MTA is a bully until we could, right? Until
Did you guys ever get an answer to the why?
No.
About the girl? No?
I have a theory. I think they just, they took advantage of the fact that there's a 15-year-old girl who saw somebody get hit by a train. She admittedly was having a panic attack. Within an hour of this happening, the transit police went to the hospital to take her statement. This is allegedly. I didn't see any statements from her that day, but this is what, allegedly what she said. And then 2 years later, an investigator, quote unquote, right, shows up to her house and says, "Hey, can you give us a statement about that train accident case that you witnessed 2 years ago? It's going to trial." So her explanation was, they didn't talk to me about the case. They didn't ask me any questions. They didn't tell me what they thought happened. They just showed up, knocked on my door, said, "Can you write a statement?" And she's at that time 17 years old. She says, sure, no problem. Have a nice day. I'll write a statement. I'll get it to you. And then she goes to her computer and types up a full page statement, signs it. Her mother signs it because she was 17 at the time. And then somehow they get it back. She didn't remember, but they got it back to the MTA, unprompted, assisted. Just that was her statement 2 years later. And it was
like she didn't remember turning the letter into the statement.
No, she didn't know how
MTA?
she got it to them, but she knows that she didn't write it while they were there. They didn't help her write it. They didn't ask her any specific questions. So we're sitting down for her video deposition now, 2 months before trial, right? And obviously now that I know about this witness, we need to do a deposition. So the lawyer for the MTA gives me her information, says, all right, she's in Connecticut. We're going to call the deposition, obviously, so they could lead it, right? Because whoever notices the deposition goes first. So we're going to call the deposition, and I see on the notice it's going to be video recorded. Thinking to myself, that's weird. Like we didn't record any other depositions. It's becoming more normal, but it's not like the norm. So I said, okay, they'll video record it. We'll see, where it goes. And we sit down in her kitchen in Connecticut, and I'm looking at her. I'm like, she looks like a regular, like credible. I was like, what the hell? I actually turned to my client afterward. I was like, is there something that I need to know here? Like this, what? She has no reason to lie. She seems credible. She's not. She has no issues, criminal issues or problems that you would think, okay, maybe she's not the most credible. I would love to have had her as our witness. She was great. And that's when I called Jessica and I said, hey, Jessica, remember that case you're going to fly out, and we're going to pick the jury in May or whatever it was, June, whatever it was first scheduled. I said, I want to send you this video and watch it. It's about an hour long, and call me back and tell me what you think. So
Jessica, what'd you say?
Settle.
Nick,
Literally, send me the instructions to return the retainer. I'm going to refund the retainer. What are they offering? You try to push it and settle the case. And honestly, we started talking to them about, hey, where are you guys on this? This is a no pay. Maybe I can get you $100,000 or something along. I can get you something. But this guy tried to kill himself. We have the cleaner, the operator, and this independent eyewitness. Where are you going with it? We went from, we think we have a nice case here, to, oh my God, this is a real problem. And then when they gave us no choice, we said, all right, screw it. We're going to go. Like they're offering us nothing, maybe $100,000, which they ended up offering us officially, but they're not leaving us any choice. Okay, so let's let it go. And then that's what we did.
I was going to say, so here are the sketchy parts that we figured out after we were forced to go further into this case. Okay. If you look at her statement, they call it a statement. We call it an affidavit. It reads like an affidavit. My name is, I live at, I am this many years old. Throughout the whole thing, she calls him the male. The male did this. The male did that. The train conductor is not at fault. The platform was clean and dry. There was nothing wrong at the train station, and ends it with, this is my statement to the best of my recollection. Uh-huh. So when I read the statement, I said, okay, well, this is something, because there's no way a 15-year-old wrote this. And now, again, why she stuck to it, I have no idea. But like watching her deposition video, that was like, oh, this is a problem. But then I guess once you really started looking at the statement, it was like, wait a minute, this doesn't match. This doesn't feel right. Right. And once you put it together with other facts, so why is there one witness? Why is the 15-year-old the one statement they have? The 20 or so other people on the platform didn't see it.
Probably 100 people.
Okay. Nobody else had a statement taken. And then you put together the fact that the MTA followed her over to the hospital to take her statement immediately. The MTA also tried to approach the client twice in the hospital to get his statement at that time. When they couldn't get his, they went over to her. So it was these facts that we put together for the jury to lead them through. Here's the timeline. Now, the statement we were iffy on putting in or not, it ended up coming in anyway. But all of those things put together is what led them gently to the fact that something's going on, which is, I think they ended up where we ended up, which is something is definitely going on, but I have no idea why.
Well, they definitely ended up there. I spoke to them after. They certainly agreed that statement, in their opinion, was not independently authored by the 17-year-old. My theory was they show up with a pre-written statement, say, hey, remember that horrible thing? We're so sorry. It's so traumatic. I can't believe, that you had to see this. Do you agree with everything here? Great. Sign here and we'll be on our way. That's what I think happened. And luckily the jury thought the same thing.
Yeah. You never at one point were like, this girl's lying.
In closing, I mean, I didn't say lying, but in closing, because we were wrestling with the issue of, hey, if a jury isn't sure and this statement is put in, and we were thinking about putting it in ourselves, like offer the statement. The transit, they weren't going to object to it because the statement is like, it's something out of a summary judgment affidavit that, you would expect one of their employees to sign. It was like perfect for them. So I knew they wouldn't object to it. So we kept it aside. There's no reason for us to put it in. We said we don't have enough to call them, liars or we don't have it yet. We can insinuate and cast some doubt, but we don't have it. It wasn't until days of their witnesses just getting crushed. There's no other way I could say it. Their witnesses were destroyed. I remember texting my brothers after I sat down after crossing their engineer, and I just said, I just decapitated their engineer, and his body is laying on the Grand Concourse. That's the street right outside the courthouse. And they said, great, keep going. And then I just kept going. But we didn't have it. And then right before they rested on the last day, the attorney stands up and says, Your Honor, I'd like to move the statement into evidence. And I objected. I said, her testimony came in. This is pure hearsay. I don't know why a statement that we obviously didn't cross-examine her. It's a one-sided statement. Why would this come in? The judge let it in, so now I have to deal with it. And it wasn't until closing where I put the statement up on my TV, and then we just started going, hey, it's there. They're either going to believe it or they're not, so now we have to go all in. So that's what we did. And I started by pointing out things like Jessica said. What 17-year-old is going to write a statement like this? Number one, true to the best of my knowledge. It's written in such a way. It's such a formal.
Like, GPT wasn't around back then.
So GPT wasn't around, and just it was written like she was a police officer. I mean, the male did this. The male in the blue shirt. And it didn't make sense. So I started pointing that out, and I think it started sparking the jurors' curiosity. So what I did was I flipped over to the statements from their employees and their incident reports. And I had, I think, 2 or 3 of their incident reports up on my screen side by side. And there's one key thing that the Transit Authority, they put in all their reports. And it's in all 3 of their reports that I put up. And I highlighted each section side by side. The floor was dry, the area was clean and well lit. Something along those lines. Like they always put that in there, even though it has nothing to do with this case, right? Like we're not alleging a slip, we're not alleging garbage, we're not alleging a lighting issue, but they put it in there because they always do. That's how they're trained. So I put those 3 up there, and I'm like, why are they writing these things? And then what I did was I moved all 3 over and I added hers next to it. And there was one sentence in there just kind of jammed in. And it said, I was standing here, whatever. And the one sentence was, the floor was dry, there was no garbage. And it was almost like an exact, the words were a little bit different, but it was almost exact. And I said, their fingerprints are all over this.
Nice.
Who writes that? It's ridiculous that they write it. And I spoke to the jurors after, and to them, they were like, yeah, I mean, that's a breadcrumb right there that you can't ignore.
I'm for some reason I'm getting like odd parallels to A Few Good Men, and like it's kind of like you could have had a code red moment, you know what I mean? It's like you faked this statement, didn't you? But you didn't have to do that.
Well, honestly, we didn't have her there. We wanted her live.
Oh, but she wasn't there.
We couldn't get her.
They just played her video. They wouldn't. They said we couldn't get her. She's unavailable. My office called her 2 days before. I'm available all month, except for it was Juneteenth. I'm not available on Juneteenth, but I'm available all month. And my thought was, if she comes live, I have to attack her. Like, I'm just going to go crazy and go in and just rip apart her statement and try to see if I can get her to break down on the stand. But I didn't have that opportunity because she was unavailable. And that was something that I said in closing as well. I said, was this witness who we sat in her kitchen a month ago and took this video recording and is so helpful writing statements and all this stuff, was she unavailable or was she made unavailable? Like, I mean, I even said, I hate to sound like a conspiracy theorist, but let's look at what the evidence shows. And then I put that in there. And then we put the side-by-side, statements and the little, the similarities in the statements. And the jurors, they didn't go for it.
When it went to the jury, Jessica, how did you feel?
I felt good at that point because he had been keeping me up to date. I mean, he would say, I don't want to overshoot this. And I think it went well, but you never know with jurors. And so I thought it went well. I thought that once we could show that the timeline and the weirdness around that statement, that people would get on board with it. I mean, we didn't do a regular focus group, but anybody I talked to about the statement would always say, oh, no way. So I think I felt like we had them. Nick got a little bit nervous when they were deliberating because they were sending out a lot of questions. And I said, they were half a day or more in. And I said, are there any questions? And he sends me like 3 pages of like screenshot questions. I said, oh my God, are those questions or those are your notes? He said, no, those are all their questions. So he was getting a little nervous at that. And they went into the second day, right? They didn't finish that first day. And then
the first day, it was towards the end. We were closing at, I think, 3:30 or like 3 o'clock on a Friday. And so we closed and I sat down from closing. I'm like, we got it. We're good.
And that's where you did ask. You did ask for a number there.
I asked. And I sat down and I thought it was well received. Jessica gave me, and I'll be upfront about the night before. I was asking Jessica, how the hell? What am I going to ask for? How the hell am I going to ask for this much money?
Right.
This is a case where they might already have reservations about, is this guy committing suicide or what? What if I turn them off by asking for a big number? So we kind of talked about that, and she gave me a nugget that I had never heard before, and it was the man in the black suit, and it's been used all over the country from what I understand now, and I learned about it for the first time the night before closing.
Oh, great! Well, now
it's a Nick Raleigh thing. I don't take credit for it.
Okay. Yeah. Well, can we talk about the man in the black suit then?
We can talk about it. Honestly, Jessica probably knows it better than I do. She gave it to me, and I did my best to figure out. Like, Jessica, I called it 10 times. Tell it to me again. Can you tell it to me again?
So this is a Nick Raleigh trial by human, trial lawyers for justice type of approach.
Yeah.
Yes.
Okay. What is it?
Jessica, you got to tell it. Honestly, I don't even remember it. I did it the one time. I sat down. I was like, all right, that hit, and
now it's gone.
It's gone. I gotta learn it again.
Save me from having to ask ChatGPT.
It starts where there's a man that shows up at your client is the person who's at home or wherever they need to be. And you tell the story that Mr. Hossein is at his house and it's this date, which is the date before the incident or hours before the incident. And there's a knock on the door and he goes to answer the door and there's a man in a black suit with a black tie, sharp shoes, shiny black shoes, dark glasses. And he's carrying a briefcase. And he says, are you Mr. Hossein? And he says, yes, that's me. And he says, well, I have, and you insert whatever your number is. I have $40 million here for you in this briefcase, but I have a deal to make with you. And he says, okay, well, what would that be? I mean, I think you've got the wrong person. He says, oh, no, it's for you. But here's what's going to happen to you is tomorrow you're going to go and you're going to get off of one train and you're going to walk to the platform to the other and your foot's going to slip and you walk through the whole thing. You're going to rush to get out of the way. You're going to mostly make it, but your foot's going to get cut off by the train. You're going to get rushed to the hospital and you're going to live the rest of your life without your foot. And so your job's going to get affected. You're going to feel left out from your family. You're going to get ostracized. You walk through everything. And at the end, the client says, well, I don't want any of that. Go away, and starts to close the door on the man. And the man stops him and puts his foot in the door and says, I'm sorry, but the deal's already been made. So the question is, how do we know that that's the right number? Well, we know that that's the right number because he didn't want it. But you still have to give him something that is fair because he wouldn't take any amount of money, right, for this. But a deal is made where it's something that he could walk away with and feel like he was heard and that this was a fair representation of what was taken.
It's a little bit of a Meet Joe Black movie moment, I
Yes.
guess. I don't know if you guys remember that one.
It was, I was happy. At first I was like, I don't think I like that. It seems so dramatic. I don't know. I've never heard this before. I don't know if it's going to hit. And then I called her 10 times. Say it again. Can you tell me again? And I went for a walk. I remember I told my wife, I was like, you know how it is. Night before closing, I'm going to be in a different headspace. I'll see you after the verdict. And she went to sleep. I just started walking, and I was just like talking to myself. My neighbors probably thought I was crazy. I was walking around the neighborhood, and it's pitch black, and I was gone for a few hours, and I was just talking and walking to myself. And I was like, all right, I think I'm comfortable with how I can do it, my tempo. I think I got it down, what I'm going to ask for, how I'm going to do it. I'm going to do a knock on the door, which I did in closing. I tried to really make it visual, that they're seeing this guy in the black suit with the black shoes and the black briefcase and the black tie, and he pulls up in his black SUV and he knocks on the door, and Maroof stands up on his own 2 feet that he has, and his back, he could stand up straight because he's a healthy 24-year-old. And the guy says to him, "Are you Maroof Hussain?" "Yeah, I am, but how can I help you?" And I said, "I have $30 million in this briefcase for you, but I want to make you a deal. You got to earn it."
Would you be allowed to put a briefcase on the table?
I mean, I use a lot of demonstratives. I had a full skeleton in the courtroom. Another thing that I took from Amir, I think I took that one from. So, that's one thing that I will be upfront and honest about. And I think it's part of being a trial lawyer. No one's reinventing the wheel. It's you give, you take. There are things that have worked for me that haven't worked for others, and things that have worked for others that don't work for me. You have to kind of model your own personality, but you still use things that you learn from other people. And I'll never come at my whole trial was original. It wasn't. It's just how you deliver it, your tempo, your credibility in saying it, the way the jurors are receiving it. Do you have the right jury to use this or that? And I think I was extremely lucky that Jessica brought up the man in the black suit the night before. And I think it was the right case for it. And it clearly, it hit.
That's right. Cause, $4.5 million per toe sounds like a lot of money. Yes, I saw that. Was there any questions from the jury that really stopped you and were like, "Oh my God, I think we might lose this now"?
Yeah,
or was it just
there was a lot of them. There were four. I mean, I was taking pictures. I was sending them back to my office. Let me see.
There was the one good one that I said, I think we've got them, is they referenced something about, can we see the playback of the video for the MTA witness? The 17-year-old MTA
they called her
witness.
The MTA witness. Which,
yes,
right.
So they got that.
All of the testimony. They wanted all of the judge was like, you have to be more specific. So as they are sending out more notes, we want this portion of the testimony for this person and that. And so I was like, well, they're really. I thought
they
this
wanted
was
to redo the trial.
Done. I sat down. I thought, this is going to be a half an hour. It's over. And we break for the day, and there's 5 slips in for questions, and they're not even waiting for us to answer the first slip. They're sending out more slips, and I'm just like, oh my goodness, they're fighting. I don't know what's going on back there.
They're like, one of the questions is like, can we talk to the man in the black suit?
Yeah. So I mean, it was a little nerve-wracking, and it took a whole second day. We didn't get the verdict until late in the afternoon. And I asked them, I was like, what was going on back there? And they're like, oh, no, we pretty much knew. We just wanted to be sure. We wanted to read back of the conductor's testimony. And we brought them back into the courtroom so they could watch some of the video deposition of the 15-year-old witness at the time. So we had to play that back, some portions of it. But it got a little weird.
Yeah. Well, most trial lawyers I talk to say that juries take their job very seriously, and they want to deliver.
Yeah.
What was your client feeling like?
So I didn't have him in the courtroom. That was something that Jessica and I had discussed beforehand, in terms of having him in the courtroom, and how much to have him in the court, timing. And we actually had some really gruesome photos of his foot that the surgeon in the ER had taken. Let's flash that up, leave it up there for 2 minutes, talk about it and get it down, not bring the client in every day because we don't want them to get desensitized to his situation. Every night I would speak to him, hey, here's where we are. The offers did increase throughout the trial. They got up to an official $1 million before closing. But, at that point.
And then when you heard the verdict?
So the first number was, I asked for 10 million past pain, 20 million future pain. First number was 2.5. I was like, oh, geez, they're conservative. Oh my God, what are we going to do? They didn't necessarily follow my numbers, but in the aggregate, it came out to 22.75 million. We had a, I think it was 10 or 12 million in medicals. And the rest pain and suffering. They were a diligent jury. Let me put it that way. They were definitely very diligent. They weren't just throwing money. I mean, listen, the New York Post, this is what they do. This guy, after all the hell he's been through, they put it on the cover of the Post and they make it seem like he's the bad guy. That's the New York Post. So what are you going to do? But there was a lot of other coverage that was more, neutral, I would say.
Yeah, well, maybe New York Post is on MTA payroll or something.
Yeah,
Jessica, as the consultant, how did you feel about hearing the verdict?
Oh, I was ecstatic about it. For a case that we thought we needed to settle, that we weren't sure how it was going to come across to the jurors, I was thrilled that they got it and that they heard him.
Nick, at the end of it, any thoughts or advice to other lawyers about bringing in a trial consultant and working with the Jessicas of the world?
I get made fun of now that I don't want to try a case without Jessica. Which, whatever, I don't care. I'll get made fun of. It's true. I don't want to try a case without Jessica anymore. This is our second or third trial together. We're developing kind of a familiarity, I would say, where listen, you got to have the right case for it too. But I think it's invaluable in terms of framing, and that's mostly what we've been doing is framing. I will do the big data at some point. She's been pushing me for that. She hasn't led me astray so far, so I'll trust her and we'll try it.
And he has a courtroom in his own office, so we can do some focus groups very easily too.
It gives you a nice perspective from both sides, on the same case. And, we want our courtroom to be used. I mean, we're opening it up to any plaintiff's lawyer that wants it. Come on, we're not charging you. Just go use it. We want to foster that experience. We want to teach other attorneys how to do things. Like I said, I've been taught, right? I take things from other trial lawyers. I consider myself a student. I've had some success in trial, and I think it's part of my obligation to pass it on, because I'm going to learn more from someone else and they're going to teach me something, and someone that's got less experience is going to tell me something that I'm going to use, and someone with more experience is going to tell me something that I'm going to use. And if you don't have that, and I think that's something that New York specifically is missing. I see it around the country a lot that, different states are more collaborative. I think New York, just the way it is, it's super competitive. It's super insulated. It's a different type of animal, which has its own place. But I think we need to kind of open things up a little bit, because not a lot of people are trying cases anymore. I go to court and I see the same trial attorneys, and a lot of them are much older. Not to say that's a bad thing, but I don't see a lot of the newer attorneys, the newer generation. Everybody wants to say I'm a trial lawyer, but not everybody
going to trial.
Is going to trial. Yeah.
All right. Well, you guys heard it. 40 Wall Street, that's Liakas Law. They got a courtroom there. Nick has the invite out. Take advantage. Start collaborating in New York. I'm a West Coast boy and see a lot more open, I think, conversations. I don't think, I love New York, but there's no way I could survive there. I would be eaten alive. But Nick, Jessica, thank you for joining us and contributing to the Trial Lawyers Journal. This was a lot of fun. Thank you so much.
Thank you.
Thanks for having us.